If you are over 60 and own your own home, your most valuable asset is sitting completely exposed right now. And the state has a legal framework ready to strip it away from your family if you do not file 5 specific documents. You worked your entire adult life to pay off that mortgage. You sacrificed, you budgeted, and you built a foundation for your family. But without these exact legal shields in place, a sudden medical emergency or a routine trip to probate court can force the immediate sale of your house, leaving your children with absolutely nothing. Today, you are going to learn exactly which 5 pieces of paper you need to lock down your equity, and I am going to reveal a completely legal, highly guarded document at the very end of this video that actively protects your home from being seized by Medicaid to pay for nursing home care. Over my years of examining how families navigate the terrifying maze of estate planning and asset protection, I have seen the exact same tragedy unfold time and time again. Good, hardworking people who did everything right, who paid their taxes, who maintained their properties, end up losing their generational wealth because they believed a simple will was enough. I am here to tell you with absolute certainty that a will is not enough. A will does not protect your home while you are alive, and it certainly does not prevent the agonizing, expensive process of probate when you pass away. A will is simply a letter to a judge asking for permission to distribute your assets. In this video, we are going to walk through 5 crucial documents that bypass that broken system. We will start with a simple filing that keeps your house out of court, move through the essential papers that keep you in control of your property if you become incapacitated, and finally, we will break down the exact trust structure that creates an impenetrable fortress around your home. The first document you must file is called a transfer on death deed, sometimes known as a beneficiary deed. I am placing this right at the beginning because it is one of the most powerful, immediate, and cost-effective ways to protect your family from the nightmare of probate court. When you pass away, if your home is only in your name, it becomes a trapped asset. Your children cannot legally sell it, they cannot legally refinance it, and they cannot even legally speak to the homeowner's insurance company about it. The only way to unlock that asset is to take your will to probate court. Probate is a public, drawn-out legal process where a judge formally transfers ownership. Now ask yourself, do you want your family spending thousands of dollars on probate attorneys just to inherit the home you already paid for? Let me paint a picture of what probate actually looks like for the average family. It takes anywhere from 9 months to 2 years to resolve. During that entire time, your house sits in legal limbo. But guess what does not stop? The property taxes, the utility bills, the insurance premiums, and the maintenance costs. Your children, who are already grieving your loss, now have to reach into their own pockets to float the carrying costs of your empty home for over a year while lawyers argue over paperwork. Furthermore, in many states, probate attorneys are allowed to take a statutory fee based on the gross value of your estate, not the net equity. That means if your house is worth $500,000, but you still owe $200,000 on a mortgage, the lawyer's percentage is calculated on the full $500,000. They could walk away with tens of thousands of dollars of your family's money for doing basic administrative paperwork. A transfer on death deed bypasses this entire nightmare. It is a simple document that you file with your local county recorder's office while you are alive. It states that upon your death, the ownership of your property automatically and instantly transfers to the beneficiaries you have named. There is no judge, there is no probate attorney, there is no 9-month waiting period. When you pass, your children simply present your death certificate to the county and the house is theirs. You maintain total control over the property while you are alive. You can still sell it, you can refinance it, or you can even revoke the deed entirely if you change your mind. It offers complete flexibility for you and absolute seamless protection for your heirs. If your state allows transfer on death deeds, and more than 30 states currently do, this is a non-negotiable document you must file immediately. Did you know that nearly 70% of adults over the age of 65 will need some form of long-term care, and a massive portion of them will face a period of mental incapacity before they pass away? Think about that for a second. We spend so much time planning for what happens after we die that we completely ignore what happens if we live, but lose the ability to make our own decisions. This brings us to the second absolutely vital document, a durable power of attorney for finances. Many people mistakenly believe that if they suffer a severe stroke or develop dementia, their spouse or their adult children can just automatically step in, manage their bank accounts, pay the mortgage, and handle the property. This is a massive and often devastating misconception. If your name is on the deed to your house and you become medically incapacitated, your family cannot legally sign your name to sell that house, to refinance it to pay for your medical care, or to access a home equity line of credit. Your equity becomes frozen. Without a durable power of attorney, your family has to go to court and sue you for the right to manage your life. This process is called guardianship or conservatorship, and it is one of the most humiliating, expensive, and restrictive legal processes in existence. Your children will have to hire a lawyer, stand in front of a judge, and present medical evidence proving that you are incompetent. The court will then appoint someone to manage your finances. Sometimes the judge appoints your child, but sometimes, if the judge spots any family conflict, they will appoint a complete stranger, a professional, court-appointed conservator. This stranger will now have total control over your home, your bank accounts, and your life. They will charge by the hour, draining your life savings, and they will have the power to sell your house to pay for their own fees and your medical care, whether your family likes it or not. A durable power of attorney for finances prevents this entire catastrophe. By signing this document while you are of sound mind, you are legally designating exactly who has the authority to handle your real estate, your taxes, and your money if you ever lose capacity. The word durable is the key here. A standard power of attorney expires the moment you become incapacitated, which is the exact moment you actually need it. A durable power of attorney specifically states that it remains in effect even if you lose mental capacity. Having this document safely filed away means that if the worst happens, your trusted son, daughter, or spouse can immediately step in, deal with the mortgage company, pay the taxes, and protect the home without ever having to ask a judge for permission. Let me ask you another question. Have you looked at the cost of medical care recently? We are seeing seniors survive incredible medical emergencies, only to be financially ruined by the aftermath. This leads directly to the third document you must put in place, a declaration of homestead. Depending on the state you live in, the equity in your home is vulnerable to outside creditors. Imagine you have a medical emergency. You spend 3 weeks in the intensive care unit, and you are hit with a $200,000 medical bill that your insurance refuses to cover. Or imagine you are in a minor car accident, you are found at fault, and the damages exceed your auto insurance policy limits. The other party or the hospital can sue you, obtain a judgment, and legally force the sale of your house to satisfy that debt. You could be evicted from the home you paid off 30 years ago, all because of one stroke of bad luck. A declaration of homestead is a legal document filed with your county that places a protective shield over a certain amount of your home's equity, making it completely off limits to most unsecured creditors. Every state has different laws regarding homestead exemptions. In some states, like Florida or Texas, the protection is automatic and unlimited. You could have $10 million in home equity and a creditor cannot touch it. But in many other states, the protection is not automatic, or the automatic amount is very small, perhaps only $20,000 or $30,000. In these states, you must proactively file a declaration of homestead to maximize your protection, which can sometimes shield up to $500,000 of your equity. By filing this simple document, you are putting a lock on your front door that medical bill collectors and lawsuit creditors cannot break. If they sue you, they will look at your assets, see the recorded homestead declaration, and realize that your home equity is legally untouchable. It stops predatory collection agencies in their tracks and ensures that no matter what health or legal crises arise in your golden years, you will never be forced onto the street. You must look up your specific state's homestead laws today, find out if you need to manually file the declaration, and get it recorded. As we move forward, I want to remind you that the most complex and dangerous threat to your home is still coming up. In just a few minutes, I am going to explain the Medicaid Asset Protection Trust and how the government's 5-year look-back period can completely wipe out your family's inheritance. But before we get to that ultimate shield, we have to secure the medical side of your estate. The fourth vital document is your Advance Healthcare Directive, which includes both a living will and a medical power of attorney. You might be wondering why a medical document is on a list about protecting your home. The reality is that your medical decisions and your financial survival are deeply, inextricably linked. The number one reason seniors lose their homes is because of unplanned, poorly managed long-term care and medical interventions. If you suffer a severe medical event and cannot speak for yourself, doctors are legally obligated to keep you alive using every artificial measure available, regardless of the cost or the quality of life it provides. Without an Advance Healthcare Directive, your family might be forced into agonizing arguments at your hospital bedside about what kind of care you would want. While they are arguing, the medical bills are skyrocketing. Furthermore, without a designated medical proxy, the hospital or state social workers may make decisions about your placement after you are discharged. They might decide you need to go to an expensive private rehabilitation facility or a nursing home because no one has the legal authority to organize in-home care for you. When you are placed in these expensive facilities, the bills pile up rapidly, and eventually, the facility will look to your assets, specifically your home, to get paid. Your Advance Healthcare Directive solves this by legally appointing someone you trust to make medical choices for you, and by laying out exactly what kind of life-prolonging treatments you do or do not want. More importantly, it gives your designated proxy the authority to advocate for you to return to your home. With this document, your proxy can legally view your medical records, speak to your doctors, and arrange for home health aides, keeping you out of the institutionalized care system that so frequently bankrupts seniors. By controlling your medical destiny, you are indirectly protecting your estate. You are ensuring that hundreds of thousands of dollars are not wasted on unwanted medical interventions, and you are empowering your family to keep you in the house you love. Now we have arrived at the absolute most critical, most misunderstood threat to your homeownership. We need to talk about the nursing home industry, Medicaid, and the government's legal right to take your house. The fifth and final document you must establish is a Medicaid Asset Protection Trust, or in certain applicable states, a specialized life estate deed known as a ladybird deed. Let me explain the terrifying reality of aging in America. The average cost of a nursing home is now approaching $10,000 a month. That is $120,000 a year. Medicare, the health insurance you paid into your whole life, does not cover long-term custodial nursing home care. They will cover a brief rehabilitation period, but if you have Alzheimer's, Parkinson's, or simply become too frail to live independently, Medicare pays nothing. This leaves you with two choices: pay out of pocket until you are completely broke, or qualify for Medicaid. Medicaid is a joint federal and state program that will pay for your nursing home care, but it is a poverty program. To qualify, you are only allowed to have about $2,000 to your name. Now, there is a catch that catches millions of families off guard. When Medicaid calculates your assets to see if you are poor enough to qualify, they usually do not count your primary residence. They let you keep your house, and they will start paying the $10,000 a month to the nursing home. Families breathe a sigh of relief. They think the house is safe, but this is the trap. It is called Medicaid Estate Recovery. Federal law requires every single state to attempt to recover the money they spent on your care after you die. So you spend 3 years in a nursing home, Medicaid spends $360,000 on your care, and then you pass away, the state will immediately place a lien on your home for $360,000. Your children cannot inherit the house until that lien is paid. In almost every case, the family has to sell the house, hand the entire proceeds over to the government, and walk away with nothing. Your life's work, your generational wealth is wiped out to reimburse the state. You cannot just give your house to your kids right before you go into a nursing home to avoid this, because Medicaid has a strict 5-year look-back period. If you transfer your house to your children and then apply for Medicaid within 5 years of that transfer, the government will penalize you and refuse to pay for your care for months or even years. This is why the Medicaid Asset Protection Trust is the ultimate defensive weapon. This is an irrevocable trust designed specifically to hold your home. When you sign your house over to this trust, you retain the absolute right to live in the house for the rest of your life. You still pay the taxes, you still mow the lawn, and no one can kick you out. But legally, you no longer own the equity. The trust does. If you set this up and wait out the 5-year look-back period, the magic happens. Because you do not technically own the house anymore, Medicaid cannot count it as an asset, and more importantly, they cannot place a lien on it when you die. When you pass away, the house goes directly to your children, completely free of the Medicaid Estate Recovery Clause. In a few specific states like Texas, Florida, and Michigan, you can achieve a similar result using a ladybird deed, which automatically transfers the house upon death while retaining your life estate and bypassing the Recovery Act. Whichever tool your state allows, this is the grand payoff. Filing this single document guarantees that the government cannot confiscate your home to pay for your final years of care. It is the absolute difference between leaving your children a massive financial head start in life or leaving them with a stack of government invoices. We have covered immense ground today, and I know this can feel overwhelming, but taking action is the only way to protect your legacy. Let's quickly review the vital steps you need to take. First, establish a transfer on death deed to ensure your house skips the expensive, exhausting probate process entirely. Second, file a durable power of attorney for finances so your trusted loved ones can manage your equity and pay your bills if you lose mental capacity, keeping you out of court-ordered guardianship. Third, record a declaration of homestead to build a fortress around your equity, protecting it from aggressive medical debt collectors and lawsuit judgments. Fourth, finalize your advance healthcare directive so that your medical wishes are legally binding, preventing unwanted, estate-draining medical procedures and empowering your family to advocate for your care at home. And finally, work with an elder law attorney to establish a Medicaid Asset Protection Trust, or Ladybird deed, effectively running out the clock on the 5-year look-back period and guaranteeing the state cannot seize your house for nursing home reimbursement. This information is powerful, but it only works if you use it. I want to hear directly from you about how these issues are impacting your life right now. Go down to the comment section and tell me, have you or your family ever had to deal with the nightmare of probate? Or have you seen someone lose their home to a nursing home? Share your experience below so others can learn from what you have been through. And if you haven't started this process yet, let me know which of these 5 documents you are going to file first.